and Mr. Kalani.
Yes, sir. Good morning.
Good morning, Mr. Kalani. Mr. Stothard, are we right to go as far as you are concerned?
Yes, by all means, Your Honour. Thank you.
Thank you. Very well. Mr. Kalani, perhaps we might start by you telling me and all of us how you are going on getting other lawyers.
So the handover process for my previous lawyer will be done today, and I'm in the process of finalizing the new lawyers within another couple of days. It will take.
I didn't catch the first words you said. I heard you say you're in the process of financing your new lawyers in a couple of days. I think that was what you said. What did you say?
My old previous lawyer, KBH, had made the handover process partly on Thursday and partly today. He'll be completing all the handover process of my documents.
Yes, thank you.
I take it further to my new lawyer. Unless the new lawyer can't see the documents, I can't able to finalize the new lawyers.
Now, are you able to tell us who the new lawyers are?
I'm in process of finalizing, sir, with Overy and Angel. I'm in discussion with Overy and Angel.
Would you mind spelling that, please?
Overy, AFRIDI.
Yes.
And Angel, ANGEL.
Thank you. I'm not familiar with them. They are Dubai lawyers, are they, in the DIFC?
They are based out of Dubai in the AFC, sir.
Yes, thank you. Well, now, the next thing you might tell us about is what, if anything, you are doing about getting money to pay the security for costs.
Sir, I'm the sole shareholder of KBC Aldini Capital, and being a shareholder, I need certain time to organize the funds, and apart from that, I have to call for a special board meeting where my directors, one director is based out of Spain, the other director is based out of India. So with this, both the directors will be passing the board resolution, which will, as per the DFSA norms, minimum 7 days notice is required. After the board meeting, initially once we organize it, so my humble request is, sir, the cost of securities will be heard after the hearing, sir. I don't want to stop the hearing.
Well, that's really not an option. If the question of security is allowed to go that you simply provide it after the hearing, that defeats the whole object of it. So I think you had better put that aside, and that's really just not on the agenda. So can you explain to us why you need a directors' meeting in order to provide security?
We have to call for a board meeting, sir, as per the DFSA norms, to infuse the additional paid up capital. Once I infuse the paid up capital, then how to go to DIFC to amend my memorandum of association, article of association, to increase the paid up capital. The whole process will take minimum 15 days to 20 days, sir.
So you are intending, are you, to provide the security by putting in equity capital? Is that the intention?
Yeah, the intention is clear, sir, but I'm in the process of raising it. For the past 3 years, there is no substantial business, and my book of accounts are under loss. So I'll be going to the new shareholders to raise the funds for this concerned issue, sir.
So you are, if I understand that correctly, whereas at present you are the sole shareholder, you are intending that there will be some new shareholders who will bring in equity capital, and out of that the money will be available. Is that a correct understanding?
You are right, sir.
Right. Are you able to tell us anything about the new shareholders and their means? That is, the ability to provide the money?
Sir, everything had come to me with my previous lawyer. They verbally told it, and by 12th of February, they had sent a mail that they don't want to continue with my case. They want to terminate my mandate. So we were in the process. I requested the old lawyer to continue till the case hearing. But because lack of understanding, we are not on the same platform. So finally on 18th, we had decided to part away from the old lawyers. And everything, the process started from 19th. From 19th, I'll be starting the process after this meeting, going and meeting the new shareholders within another 1 or 2 days, sir. Because again, how to tell them what is the case, to explain the case, it will take 1 or 2 days time. So I am not in the process, but I had identified the investors who can put the additional capital along with me.
Well, now, are you able to tell us who the new shareholders are? There may be reasons why you don't want to, but it may be important for what we are about that I and the other parties know.
As on today, I don't have any particular name, sir, but I'm talking to my existing clients who can come as my shareholders.
Right. So there are no people at the moment who have said they will become shareholders and provide the money.
I had identified one investor, sir. I'll be talking to him after this court hearing.
Yeah, but can I just make it, see if I do understand it correctly, as at the moment, there is no one who has said, yes, I will become a shareholder and provide money.
There was no commitment. Initial discussion started, sir.
Thank you. Yes. Very well. Now, I have received what I call skeleton arguments that were provided by Mr. Reid, who is in London, I assume, and Mr. Holloway, who I think is on your right. Have you received those and been able to read them?
Yes, sir. I read the skeleton arguments.
Thank you.
And just now I replied the answer before I'm coming to the court, sir.
Yes. What I'm going to do is I'm going to ask Mr. Reid and then Mr. Holloway what, if anything, they wish to add in the light of the information you've provided to us all. And then I will ask you if you wish to say anything about what I should do. So, Mr. Reid, would you like to tell me, to address me any further? I should say, to set the scene, that while striking out if security is not provided, another option sometimes is a stay for a period to give an opportunity to provide security, and if that is not done, then there may be a striking out. Here, the reasons for doing that, if Mr. Aldini puts them to me, as I would expect him to, would be that his previous solicitors may not have done the best job in putting his position before me earlier, that there is a prospect of getting the security, and added to that, there is a need to get some new lawyers so that he can properly advance the case for doing so to me. There may be answers to all that, but it seems to me that it may set the scene if I indicate those as possible considerations. Over to you, Mr. Reid.
My Lord, thank you. Well, my Lord, just dealing immediately with what Mr. Kalani has sought to tell us, in circumstances where he is the sole shareholder, I'm slightly struggling with the alleged need for a board meeting with notice being served on other directors, allegedly in Spain and India. The idea that the only way in which he could raise finance or fund this would be by an increase, a raising in capital, going through all of the formal procedures required under the DFSA, I find an extraordinary proposition. I don't think I've ever heard it suggested before that that's the only way in which a claimant can fund its litigation. It has, I'm bound to say, all of the hallmarks of an effort to delay as far as possible the provision of security until we get to the point where we are exactly where he would like us to be, and he's indicated his intention in the emails. That's to say, he's providing security as at trial. We are now 2 weeks, 14 days from the trial date, and assuming that we go through this procedure of notifying board members, calling board meetings, seeking an increase in capital. There may be other stages of which he's not yet aware in terms of the DFSA, but if we do this, we will be in exactly the situation whereby we are proceeding into trial. All of the costs to which which Mr. Stothard and Mr. Roderick have referred in their witness statements have been incurred, and have been incurred without any security being provided. And in the light of the order that you made on the last occasion, my Lord, in our submission, that is entirely unacceptable. That is essentially a revocation, I'll just put it as strongly as that, of the order that's already been made without any material change in circumstance. We know.
Can I just stop you there? I think I may be able to clear the decks by saying that I am not contemplating that we in any way move to a trial without security. The alternative, the possible alternative of a stay, means things stop now. The defendant stops spending money now. However, there is a stay, there is the possibility that the case revives later on when security is provided. That may affect the way you put your submissions to me.
That's helpful. I mean, my immediate response to that is that we, to cut to the chase, the defendants, the first defendants, has real doubts that the claimant is serious about this claim. If one looks at the order that was made at the last hearing, there was, for example, provision for witness evidence and reply. There was provision for amended reply. There was provision for disclosure. There was provision for verification by Mr. Kalani that he has given all of his disclosure in compliance, I should say, with an order that was first made in October of last year. And none of that has been done. And similarly, no security, no attempt to explain why security hasn't been provided, no attempt to make any sort of alternative arrangements or proposals in respect to security. And when you look at that in the context of a claim for business losses where the disclosure has been utterly paltry, almost nothing disclosed by the claimant making a fairly extravagant claim, in circumstances where the only witness evidence that's been put in on the claimant's part is a 15-page witness statement by Mr. Kalani, where there have been no experts, and indeed an attempt to resist reliance by the defendants on experts in what was a claim for business damage to business reputation and business interruption. In those circumstances, it's really hard to see that the claimant is serious, and clearly a claim like this has massive nuisance value to defendants like my client, who has major business interests in Canada, and like the second and third defendants who have a professional reputation. And the idea that these proceedings...
Mr. Reid, I'm sorry to interrupt, but I thought that in our hearing a week ago, it was accepted that it was a bona fide claim. I have a fairly clear recollection of your properly saying that, and I don't know that we should be getting into the merits of it.
So be it, my lord. But I do. At this stage, I say that we have concerns about the way the claim is being pursued. We have a situation where we were told that the costs would be met. We were told that in sworn evidence. We were told that in correspondence. And then at the last minute, it suggested that it becomes clear that first of all, the company has no assets. It's clear on the accounts that the company has no assets. It's clear from the auditor's statement to the 2018 accounts that the company is being supported by its shareholder, by Mr. Kalani. There is every suggestion on the Amitos report that we have that Mr. Kalani has business interests, significant business interests, not only in Dubai, but in India. And in those circumstances, to then find that no security has been provided. We're now, it's not just, the security was to have been provided by the 19th. We're now some days on. So we're 10 days after the hearing. We're no further on, other than a suggestion that there is this arcane procedure that requires to be followed in order that there can be some raising of capital by an unnamed investor who thus far we're told has made no commitment, but there are initial discussions. And can I just say, on the subject of initial discussions, you'll notice from the email of Mr. Kalani that he did make an approach to my instructing solicitors. My instructing solicitors didn't have any instructions, so they couldn't pursue discussions with him. But what he then sought to do in the email to the court was to mischaracterize that as some sort of agreement that either the trial could be adjourned or that there was an agreement to defer the security for costs. So there is some suggestion that Mr. Kalani can play pretty fast and loose when it comes to alleging agreements or indeed initial discussions. There had been no initial discussions of any substance with my instructing solicitors, and I doubt very much that there have been any initial discussions of any substance with any unnamed investor. So in terms of response to what has been said, we have real concerns. I can see why, from the court's perspective, there is an attraction to directing a stay, and that the matter be essentially suspended until such time as Mr. Kalani may come up with security. But I hope the court will appreciate, from the perspective of my clients, that that's an extremely unattractive option. They look for finality. They should be entitled to finality. And as I say, in circumstances where there's an extraordinary failure to engage on security, on disclosure, and in those circumstances, when one looks at the cases, and I think your lordship may have read the Meldex case, which was attached to our skeleton, that's a case where there had been a partial failure to provide security. So there was a payment into court. That payment into court was made. There was further security that was to be given over certain residential properties, and there were issues with that. And in those circumstances, and others which I can refer to, but in those circumstances, the court struck out the claim immediately and ordered indemnity costs. Now, the first defendant isn't going anywhere near or seeking any order that is that draconian, but we are suggesting that in circumstances where, as I say, no security, no explanation, no attempt to provide any form of alternative security, that the claimant should be given a very short period of further time to provide the security. And if they can't, they are essentially put to their election. They're required to decide whether they can proceed or not. And if they can't, the proceedings have to be struck out or they have to be withdrawn. But the idea that we can somehow crash on towards trial in circumstances where, as I say, that not only have they not provided security, but they haven't filed any reply witness evidence, they haven't sought to file any amended reply dealing specifically with the Morgan issues to which they can obviously speak and plead, where their disclosure is still utterly inadequate, and where they failed to provide the ordered security. In those circumstances, we say it's entirely reasonable that the matter should be put. This case should be put out, should be struck out, and shouldn't be left hanging over the defendants by means of some form of stay, by which Mr. Kalani and KBC can bring it back to life at some future stage. My Lord, if you were minded to make that sort of stay, we would seek a tight period of time. As I say, it seems intolerable from my client's perspective that this should be left hanging out there as a sword of Damocles hanging over my client.
Yes, thank you, Mr. Reid. And Mr. Holloway, what would you like to say?
My Lord, all those points indeed we would repeat, but also looking at the time scale here, we've had repeated assurances from Mr. Kalani that these costs will be paid, but when those assurances were made, it seems that there was absolutely no mechanism in place for the costs to be found. So one has to inquire, why was it being asserted that those costs would be paid after the trial, which is only a couple of weeks away, when, from what Mr. Kalani said this morning, that there's nothing concrete in place to suggest that there's any likelihood that the costs will be paid. So it's the inconsistency between the statements that we would highlight. Secondly, lateness was taken into account at the last hearing, in fairness, but the claimant's been on notice from December that this is a live issue, and appears to have made no efforts at all since that time to raise these funds. And I would also submit, my Lord, that embarking on litigation like this, it must have been a live consideration that cost orders and security for costs would be something that the claimant should have given in mind to raising those funds from the outset, certainly when the matter became live. But it seems from what Mr. Kalani said today that they're just getting around to it now, and they may be starting talking to some unnamed people who may, it's just not concrete enough, and it's too late in the day, my Lord. The second thing is the conduct of the claimant at the last hearing. There was every opportunity for any difficulties, including technicalities about board meetings and so forth, to be raised at that point. And my Lord, you will remember, it was quite extraordinary that no instructions, no thought had been given to the issue of security at the hearing. We paused, we took an adjournment for those instructions to be taken, and nothing was forthcoming. So, my Lord, taking that into consideration, the normal order is that security be given, and okay, we've seen Mr. Reid's skeleton in mind that practice varies among courts, but in fact the practice of the DIFC is in fact quite a lenient one, in that it doesn't build in an automatic strikeout to the security order, and it's, if you like, it doesn't put the onus on Mr. Kalani to come back and apply to set aside an order. It puts the onus on us, but the upshot of that practice is that once security is ordered and not given, dismissal and strikeout is the ultimate consequence. And if Mr. Kalani had cooperated with the court and been making efforts, and if one looks at the authorities, one sees when applications like this are made, okay, we need some more time because we have assets in a certain place that will take a bit longer to realize than we first thought, and the court can be flexible when there is something concrete like that on the table. But here there is absolutely nothing. So, my Lord, we're back in the position that we were at the last hearing. We have nothing really substantially further on the table. So, my Lord, the order that you made, there's no reason at all why it shouldn't have been complied with. And our submission is that a short period of grace, a final period is needed, but we do need the certainty, as Mr. Reid said. And one other point, my Lord, is that the alternative option that you've mooted is indeed going to be more costly, and I think Mr. Reid flagged that in the skeleton argument. We have wasted costs. We wasted costs at the last hearing. We wasted costs today. After the last hearing, my client has proceeded to engage expert evidence on Canadian law. Mr. Reid's clients have engaged expert evidence on quantum. Those costs, if Mr. Kalani had come to the last hearing and said, I need a little bit more time, the appropriate time for considering the alternative order would have been at the last hearing. But because that claimant hasn't been, I would submit, altogether frank and full with the court, we have wasted more time, more costs since that last hearing, and I think, Lord, the finality and certainty is what everyone needs here. There doesn't seem to be a concrete proposal on the table that would give anyone confidence that if in a few weeks or a few more days would actually help here. What Mr. Clanning is saying is he's just finally started looking for a source of funding, and Lord, in our submission, that's just not good enough at this point, given the time and cost that everybody's spent on this issue to date. Thank you.
Yes, thank you. Yes, Mr. Kalani, the most important point seems to be what confidence one can have that you will ever get the money.
My lord, can I talk?
Just hang on a sec. Let me explain a little more so you can see what you, as I see it at the moment, you need to really address. There's no suggestion whatsoever that you are going to put in money from your own funds. The suggestion is that money might come from unknown people who have not even been approached yet in any serious way. And this is a considerable time after attention should have been given to it. Attention should have been given to this sort of thing before the hearing of the application a week or so ago. And after that application, it should have been given to it with much greater expedition than has been shown. That's the sort of thing that you've got to face up to. So with that in mind, what would you like to say in answer to what Mr. Reid and Mr. Holloway have said?
My lord, thank you for giving me the opportunity. I want to be honestly confess, because this is my first experience and everything had come as a new to me. And yes, my lawyers, the previous lawyers, we were having a different of opinion, so we were in a discussion. And there's a huge communication gap between my previous lawyer and me. By first week of February only, they told me how, if at all, if any adverse effect will come to you, how you are going to face it. I told him, yes, definitely I'll face it. And we have an insurance in place. Now they had asked me the insurance, and now I had submitted the insurance. By 11th of February this month, sir, it came like a shock to me, because all of a sudden they called me and they told that the court is imposing cost of security. All this terminology was new. Maybe it is not the court's fault or the defendant fault, but the communication. Then I told him, sir, like the cost of security, what is the thing? The court will be imposing a cost of security of around 1.3 million. Are you going to get it? I made it very clear on the same phone. They told that they had taken the break, what you call the adjournment, in that discussion. I told him, sir, like you have to ask the court the time, and based on that thing we'll do it. All this, for the past 3 months, we were discussing the witness, Sean Morgan, that was there. Sir, honestly, I was under the belief I'm the victim of fraud and I made the losses. Yes, all my clients had backed out. I couldn't able to have any option. Yes, coming back to as and today, yes, we have some assets, even the company have the assets as per the balance sheet. I'm not denying there is no assets. And coming back to, it is like everything came as a shock, sir. Like last week only I started the process. Yes, from last week, from Thursday onwards once, because I was convincing my old lawyer to continue the case. And till that time, how to find a new lawyer, and everything was new to me. I was in the process of finalizing it. And when I talked to my lawyer, when the consent letter I was giving it by, I'm not telling by force or by this thing, I don't have any option. They started giving the termination, and we couldn't able to go in the process of what is the claimant, how to come. Not, you can check with my old lawyer, sir. It was told to me only in the first week of February. And I told them whether we have an insurance policy, whether the insurance covering or not, everything is new to me, sir. Second thing, sir, the other day when I approached on Wednesday to the court, DFC court, because my lawyers are not there, I'm alone, standalone. I came, I requested the DFC court. Then the DFC court, in the court witness only, they called Mr. Clinton. Then I told him, are you going to give an consent for the security deposit? He told that he want to check with his senior, Mr. Paul, and he'll get back to me. That was the answer I got it, and I was waiting it in the evening because I was eager exactly what to be done, what not to be done. Then I called him. That was the approach. I never approached anything on my intentionally. It was, the witness was there in the DFC court. First time I met Mr. Clinton. Then I called him. Then he told that we had not got any answer because of the time difference. With the client, they want to check it. That was the discussion, sir. The third point in this thing is that, like, Sean Morgan, the defendant, first defendant had bond Sean Morgan in the claims or in the case. I sincerely request, my lord, to you is, because it is an allegation, we don't have any relation with the client or me. We have all suffered because of Sean Morgan's mistake, but I'm not the person who had alleged anything. It is an allegation, so I want court to request to bring Sean Morgan as a witness. That is my sincere submission, sir. And the last point of my thing is, sir, yes, I'm in the process because no clientele will be giving a commitment. I don't want to give a wrong commitment to the court in front of everybody. But yes, sincerely, I'm putting my effort by. Within another 2 days, I can give the investor's name with their profile, with their balance sheet. And the last point, sir, as per the DFSA norms, when now we are increasing the paid up capital, it has to be cleared by the board resolution, board meeting. And we have to go to the DFC to register the documents to increase the paid up capital. This itself will take the process. And as of today, I don't have a lawyer. If required, I'll be coming and pleading my own case, sir. It will be like an amateur versus all the expert. Though then also I'm ready to take the risk, sir, because no lawyer is ready to take the case immediately without having, for the past 3 years, they have all the records. My sincere submissions are like, if the case is struck off, I'm not guilty, sir. I'm ready to fight. I'm ready to bring the security deposit. No negotiation for the past 3 years. Everything was, I given it to my lawyers and I never discussed. Whatever they are guiding it, this thing is there. Huge communication gap. Even I was expecting that court will be continuing them, but they told it is a consent letter. You have to give it. Without that thing, they are not going to hand over the documents. As on today also, I had not got my hand over the documents, sir. Without getting the documents, I can't approach anybody, either the investors or the lawyers or anybody. And even I'm in a fix, sir, I don't know which direction I'm going. I'm an investment banker, sir. I'm a businessman. We know to do the business, but not the legal side. And Mr. David told that the last point, sir, I wasted the time, I wasted the costing. It is not the thing, sir. I'm struggling for the past 3 years. Not only the costing side, sir, because they will keep on bringing the new defendants, they were bringing it. It took me 1.5 years to serve the notice to Mr. David Baazov. That is the argument I was having it with my previous lawyer. If at all we are taking so much time, then Norton rose, they were appointed, and we had approached them properly. Then they keep on bringing the witnesses. I was under the approach that the course, the trial, CMC, everything is there, sir. Everything is new to me, sir. This is my humble submission, and I leave the decision to you, sir.
Yes, thank you very much. Mr. Reid, I had not read the decision, the Meldex. Meldex was the name that you referred to?
Would you like me to take you to it?
Well, no, I think I have it in the documents that were sent to me by the registry together with your submissions. Give me a moment, please, and I'll read it for myself. I gather that's the, as it were, the height of your submissions.
I mean, there are specific paragraphs to which I would want to take your lordship. Your lordship may then want to read the whole case.
Well, like I see that there's not many paragraphs. Leave it with me.
Okay.
Yes, thank you, gentlemen. I don't want to hear anyone any further. I propose to strike the claim out. These proceedings are fixed for hearing for 5 days, commencing on 8 March 2020. On 13 February 2020, I heard, amongst other applications, an application by the defendants for security for costs. For reasons then given, I declined to order security for past costs, but ordered that the claimant provide security for the costs of the defendants going forward in the amount of $900,000 for the first defendant and $400,000 for the second and third defendants by payment to court by 4 p.m. on 19 February 2020. At 2 p.m. on 19 February 2020, Mr. Kalani, the sole shareholder and CEO of the claimant, emailed the registry saying first that the claimant could not arrange the funds and asking it to be allowed to provide them if and upon judgment being given against it in the proceedings, and secondly, that the claimant's retainer of its lawyers was in the process of termination and it would be engaging new lawyers. The email had not been copied to the defendants and the registry caused it to be forwarded to them. The registry informed Mr. Kalani that he should file an application. No application has been filed. Unsurprisingly, on 20th February 2020, the defendants both filed applications for orders that unless the claimant provided the respective securities within 48 hours, this claim should be struck out and judgment be entered for the defendants. The defendants' applications included the request that they dealt with without hearing. Also on 20th of February 2020, the claimant's lawyers emailed the registry advising that they would no longer be acting as the claimant's legal representative and enclosing a form of consent order signed on behalf of the claimant for an order accordingly pursuant to RDC 37.11. I considered it appropriate to make orders having the effect that the claimant's lawyers would cease to be its legal representative without a formal application. I was not prepared to consider the unless orders sought by the defendants without a hearing. Given the imminent hearing date and the continued incurring of costs, however, I fixed the defendants' applications for hearing today, 23rd of February 2020, and gave directions for service by which Mr. Kalani would be given notice of that fixture and that the claimant or its lawyer should be present. Mr. Kalani informed me at my request that he had spoken to another firm of lawyers with a view to engaging them and to making financial arrangements with them, but that he could not complete those arrangements until he had received the papers from his previous lawyers. He said that he had received some of those papers and would be receiving the remainder shortly. As to providing security, although as I have said, Mr. Kalani is the sole shareholder of the claimant, there was no suggestion that security would be provided by him or any indication of his ability to provide it. Instead, he informed me that it was proposed to obtain equity capital by issuing shares to new shareholders, the equity capital being then used to provide the security. This, he said, would take some time as it would be necessary to apply numerous formalities and hold a directors' meeting. However, as of today, no new shareholders have indicated that they will participate in this venture. The furthest it appears to have gone is that Mr. Kalani said he would be approaching a potential new shareholder following the hearing today. He said, and this could be of some importance, that he was unable effectively to approach shareholders until he had the papers from which they could judge the nature of the present claim. Implicitly, the success or failure of the claim being the key factor in any decision to participate. In my view, this is a quite unsatisfactory situation. I allow for the fact that Mr. Kalani is without his previous lawyers, although it should be said that that appears to have been a parting of the ways by consent rather than anything done by the lawyers to jettison the claimant. I have to form a view as to the prospects of the security ever becoming available. The suggestion from Mr. Kalani that security provided if and upon judgment being given against the claimant is plainly unsatisfactory, as it would defeat the entire objective of the provision of security. The option which has exercised my mind, since it would be quite wrong to permit the case to go to a hearing while the uncertain steps, if any, are taken to arrange security, is to order a stay of the proceedings for a period, giving the opportunity to obtain funds from which security can be provided. If that were to occur, the proceedings could be revived, but if it did not occur within a certain period, the proceedings would then be struck out. I have decided against that course, as it seems to me that the prospect of security ever being provided is negligible. Mr. Kalani is not going to provide it, either from choice or because he cannot. He does not have any committed equity contributor, nor any real steps towards obtaining one. And there does not seem to me to be a real prospect of an equity contributor participating in a company whose solvency is presently in considerable doubt against the possibility of success in these proceedings. In short, it seems to me close to dreaming for Mr. Kalani to think he can find the money necessary for the security from new equity shareholders. It seems to me that in that situation, it is best to strike the proceedings out now. I do not think that in the circumstances as they have been demonstrated, it is even appropriate to permit the 48 hours requested by the defendants. There is just no point to it, and it would only mean more incurring of expense, as they would prudently continue on another couple of days of expenditure of costs. That reason, it seems to me that the security not having been provided in accordance with the order made on the 13th of February, the proceedings should now be struck out. Mr. Reid and Mr. Holloway will get to the precise terms of the order in a moment, but what happens about the Part 21 claims?
Well, the Part 21 claims are, there is the existing Part 21 claim against Mr. Chegadaev. From memory, that's a pass-through claim. So essentially, we are seeking the amount of any liability that accrued to us in these proceedings. So these proceedings having been struck out, my understanding is that all of the proceedings should be struck out. I haven't had the opportunity to take instructions on that, but I don't, insofar as we were seeking an unless order, we weren't seeking any special protection for the Part 21 proceedings against Mr. Chegadaev. So as I understood it, what we were seeking was an order that the entire proceedings should be struck out. There may be, it may be that we need some special provision in respect of costs, and perhaps the reason why we haven't addressed it directly up front is the fact that Mr. Chegadaev, as we understand it, has not engaged with the action in any meaningful way. But we would certainly, I suspect, want the protection if the Part 21 proceedings are to go with the main proceedings, that there be no order as to costs as a minimum in respect of the Part 21 proceedings. I wonder whether we may just, it may be worth the parties seeking to agree detailed terms of an order now, and perhaps resuming in half an hour. I don't know if that is a suggestion which finds any favour with other parties, but that may be a sensible way of trying to, rather than trying to draft it now by submissions and committee.
Well, I don't know that a detailed order for striking out is needed. It surely is just an order for striking out. The question is striking out how much. I don't know that I could make a cost in the Part 21 proceedings without at least the opportunity for Mr. Chegadaev to be heard. I am not presently aware of whether his participation has been such that there might be some costs that he might seek to claim if the claim over against him goes away. Can you help me on that?
Well, I should say that he has been given notice of everything, and you will remember the alternative service direction, so that a further email address. So my understanding is he's entirely been notified of all of the hearings, all of the documents that have been served. So insofar as he's not here, that's a matter of choice on his part.
I doubt that he's been given notice of this application, though.
I can't speak with any knowledge of that, but my expectation is that he has been.
Anyway, can we go back to perhaps a more concrete question? For example, has he filed a defence to the Part 21 claim?
No, my lord.
It's been pretty well no activity at all, has it?
Well, there's the email to court, which we had in the previous bundle, which is where we got the iCloud email address. But otherwise, there's been no substantive engagement with the process or with the court. Well,
it strikes me, and this is for your response, and so that Mr. Holloway can take it into consideration also, that first, if the claim is struck out, it would be appropriate for me to also strike out the Part 21 claim, because there is simply no point to it. But that as to costs, I could simply reserve any question of the costs of that Part 21 claim. And I suppose there is a severe likelihood that nothing will ever be heard of it again.
That seems to me as a sensible approach. I would need to take instructions before agreeing to it, but that seems sensible to me as a way of dealing with the narrow issue of the costs of the Part 21 proceedings, that they be reserved.
Well, if you're going to need time to take instructions to agree to it, you're going to incur yet more costs.
Well, I think I'm suggesting that I seek to speak to Mr. Stothard, and I could hopefully do that without any further cost being incurred. Yes. I know he's listening. He's on this call, if you like, at this hearing. It may make sense that he and I speak, and it may be that he wishes to speak to Mr. Roderick about the form of an order that both the first defendant and the second and third defendants are content with. So I wonder if we do just rise for half an hour to give us that opportunity.
Yes, Mr. Holloway, what have you got to say? Anything more, or is that really the story?
That's perfectly fine with us. We take the break and allow us to read the films. So hopefully we can finalize.
Thank you, Mr. Reid. You did have a draft order provided earlier. Can you tell me whether that is in the?
It is in the bundle. It is in the bundle, my lord. There's a consolidated order in the bundle.
It's 31.
I have difficulty in accessing the bundle, I'm afraid.
Well, yes. Perhaps I think Mr. Holloway had the reference.
It's 31, Lord, I think. And 31.
Give me a moment, please. Yes. I think I will agree with your suggestion of a short adjournment, Mr. Reid, so that you and Mr. Stothard can communicate, and Mr. Holloway may or may not need to take instructions also. Can we make it about 20 minutes? I hope that that should be enough. And if you could have draft something up to take account of the slight change in circumstances, please include the Part 21 claim and contingently reserve costs of the Part 21 claim.
My lord, yes. But the only thing that you might consider whilst we rise is the summary assessment of the costs of today. Your lordship will see there are two schedules.
Yes, I've seen
that are at the back of the bundle. So we will be seeking the summary assessment of those costs.
Yes, yes. I have looked at them and considered them. You would be entitled to costs. The amounts, I think, are pretty high. I would have in mind quite considerably less, in fact, than those assessments. So you can put in the orders 20,000 for the first defendant and 12,000 for the second and third defendants.
My lord, I'm grateful. So, my lord, it's now 7:05 my time. So if we aim to resume at, should we say 7:25? Or I think it's 25 past 6. Make it half past.
25 minutes. Yes, thank you. What I will do to avoid technical problems which I'm prone to is leave the screen here going, go out and shut the door, and I'll return into the room in 25 minutes.
Well, that's okay.
Yes, are we ready to resume?
Yes. Sorry, Rick, you're still on mute. There you go.
Can you hear me now?
Yes.
My lord, I apologise for that. My lord, a draft order has been agreed as between the first defendant and the second and third defendants' legal teams. I understand the registry may have emailed to your lordship a copy of that draft order. I don't know if your lordship's received it.
I'll just check. Not yet, but give it a moment to see if it'll tell me more. One moment while I print it out. Naturally, now is the time the printer is starting to clean its printing heads.
My lord, while we wait for that, I had one very minor submission, if I may, on the cost of today.
Yep.
Just simply submit that the figure of 12,000 is perhaps a bit brutal in the sense that the first defendant, second and third defendant's application involved pretty similar amounts of work, pretty similar amounts of documentation, and pretty similar amounts of hearing time. Of course, they overlapped, but that's not necessarily something that we can avoid. Although at the last hearing it is true that the applications made by the defendants were very different and that the first defendant had made much more extensive applications, today I would submit that the work done would have been comparable. The cost schedules figures were pretty comparable, and I would submit that the figure perhaps should be a little more comparable. That's all I would say.
Thank you, Mr. Holloway. I appreciate what you have said. If anything, that would be an argument for reducing the figure allowed to the first defendant. It's not a large application. Thank you. I will not change.
Thank you, brother.
Yes. Mr. Kalani, you've seen this, I trust.
Pardon, sir?
My lord, he's not seen this order yet.
No, I had not seen it. My lord had not seen it.
Right. Well, you certainly should see it. Can a copy be provided to Mr. Kalani, please?
That's been done now. Well, there's some printing problems here at this end as well, but we will show Mr. Kalani online.
Mr. Kalani, just read it to yourself and then we'll go through it together.
Yes, my lord.
All the stuff starting with the upons in it is formality. There's one comment I'll make to the registry about that, but don't worry about that. The paragraphs numbered 1 to 5 are the relevant orders. I think they do give effect to what I've decided. The first one says that your company's claim is struck out. And the second one, which is another way of doing the same thing, is that there's judgment for the various defendants. The effect of that is that that's the end of your claim. The third one is then the costs, and you heard Mr. Reid and Mr. Holloway ask for those costs, and I had those cost assessments and didn't give them as much as they would have liked. The fifth one is paragraph number 5 is one which you don't have any particular concern in. That's getting rid of the claim over by them that they made against the Part 21 defendants. That's Mr. Chegadev and his company. So I think these orders do what I had in mind, and unless you have something to say about the way they are written as distinct from what I've already decided, I'm going to make those orders.
My lord, I can understand because it is my first hearing. So what my understanding is, hereafter the case will not go further.
That is the short result, yes.
And the second thing is, I want to produce the file of Sean Morgan because that is the reason we are here. I become the victim. Maybe the defendant become the victim of Sean Morgan. Unless I bring him as a witness for the case for Sean Morgan, how can I proceed with the case? I can understand. I respect your decision. I'm not challenging that. But without at this moment, without a lawyer, I came here because of the urgency, and we are making the provision. Till now, we have not got any files. I request, because if at all you are striking out, I don't have any other further proceedings or opportunity to defend myself.
I'm sorry, I don't think, I'm not sure that I quite understand what you're saying. Would you mind saying it again, please? There was a certain amount of echoing, but apart from that, I didn't quite get the drift. So tell me again.
My submission is, sir, because I become the victim by the defendants, by the ECL, and the defendants had bought Sean Morgan as a 10th defendant, and we want to fight. I bought the file so that I request my lord, that I want Sean Morgan to come as a witness for the further proceedings. But if the proceeding got stuck out, I don't have any opportunity to move forward with the case, which I'm suffering for the past 3 years, sir.
Well, if your case is brought to an end, at the moment your case is not a case against Sean Morgan. So this does not say anything one way or the other about whether your company can sue Sean Morgan.
No, sir. The defendant had bought Sean Morgan as in the file as the thing. I want Sean Morgan to come as a witness to proceed my case. But if the case is stuck off, I don't have any further opportunity to fight my case. To plead my case as I'm the innocent, sir. Like I don't have any answer to say. I don't know.
Well, when your case is struck out, then the case is ended, and there is no question of anyone calling Sean Morgan as a witness. At present, he is not a party in the case at all. And if the case went ahead, The prospect of anyone calling him as a witness, I would have thought, would have been remote, but that is just not a prospect at all when the case is struck out. If, as I thought you might be saying, you were concerned about whether you would have a claim against Sean Morgan, I repeat that this does not say anything one way or the other about that.
I don't have any claim against Sean Morgan, sir. I have a claim only against the first and second and third defendant.
Right. Well, in that case, what happens about Sean Morgan is nothing to do with the result that is going to occur when I make these orders.
Defendant 1 and 2 and 3, they bought the checkered of Sean Morgan. I don't have any against these people, sir. Now I know them checkered off because they only bought these defendants in their claims. My claim against my claim. My case is very simple, sir. Like the fraudulent letter was created, no one concerned with me. If at all I strike it, can I go for a further appeal with you, sir? For this case, no.
You are entitled. You have a right of appeal with leave against the orders that I'm about to make. You have that right. You can apply for leave. That application would come first to me to decide, but depending if I declined it, you would have the right to ask the Court of Appeal to give you leave. That might be something which you should take up with your new lawyers if you engage them at least for that purpose. You should certainly get legal advice before you do anything about that.
Definitely.
Right? Okay. Yes, thank you. The only other thing before I make these orders is that in the reasons I gave, I referred to the prospect of getting the money as being dreaming. That was not a very nice way of putting it, and I do apologise for putting it that way. Better words, which I think convey better what I meant, would be to say that it was wishful thinking. So when I correct the reasons, which will come to me after they've been typed, I'm going to put in wishful thinking instead of dreaming, which I think is a more polite phrase and better expresses what I had in mind.
But we have an insurance policy for the company, sir. That was not disclosed in the past. We have an insurance of, if at all any adverse effect will come, we had submitted my old lawyers the insurance policy. Unfortunately, that was not submitted to the court regarding my insurance. We have the indemnity insurance on the firm, any adverse effect. That was not at all discussed in our case, in the process.
Well, I think that's all beside the point as things presently stand.
In the past, we had not done it, and I humbly submitted what is my intention to bring the new further funds, because we have to go for the board resolution, board meeting, and to call for the special meeting also. It will take minimum 1 week to 10 days. If I humble request is, if at all you can give me the permission to continue with the hearing.
I've already given the decision, Mr. Kalani. Rightly or wrongly, I've given it, and I'm not going to change it now.
Okay, sir.
Thank you. Well, I'll make the orders in paragraphs 1 to 5 of the form of draft orders that has been provided. For the registry, I would simply ask that another upon be added to say, and upon hearing counsel for the first defendant and counsel for the second and third defendants, and Mr. Kalani on behalf of the claimant at a hearing on today's date. Another recital to that effect, please. Is there anything else, gentlemen? Mr. Reid, anything else from your point of view?
My Lord, My lord, no. Only to thank you for hearing this with some urgency, my lord. It will save my client a significant amount of costs.
Mr. Holloway, anything more?
Lord, no, thank you very much.
Mr. Kalani, bearing in mind what I've said, that I've made the decision and given effect to it. Anything more you wish to say?
I have nothing to say, sir. It was.
Thank you very much for your attendance, everyone, and the hearing can now be concluded.